Today we're going to talk about family law matters when legal aid is available. In this session, we will cover 4 eligibility tests that are applied when determining an application for legal aid. We will look at when legal aid is available for family law matters. We will then go through a case study, which will give you a sense of the types of family law matters we grant aid for. We will then go through the policy resources that are available for you and your staff. There are 4 eligibility tests that are used to determine eligibility for legal aid. The first is the jurisdiction test, and this asks whether legal aid is available for my matter. This will include crime, civil, and family law matters. The means test. This looks at the income and assets of the applicant and any financially associated person. There is a means test module that you can also look at, which goes through the means test in detail. The merit test. The merit test applied in family law matters depends on whether it is a Commonwealth or a state matter. Merit test A is applied in state matters, and it looks at whether it is reasonable in all the circumstances to grant aid, taking into account the nature and extent of any benefit that the applicant might expect to gain by receiving legal aid, or any disadvantage or harm to the applicant that might result from being refused legal aid, and whether there are reasonable prospects of success. Commonwealth Family Law Matters applies Merit Test B and has 3 prongs. The first part is the reasonable prospects of success test. The second is the prudent self-funded litigant test. This test requires legal aid to be satisfied that a prudent self-funding litigant would risk his or her funds in proceedings for which legal aid is sought. The third limb of the test is the appropriate spending of limited public funds test. This requires legal aid in assessing an application to consider the overall benefit to the applicant, or in some circumstances, the community, of spending limited legal aid funds on the proposed legal action. Slide 4 asks why we have these tests. So, when spending public funds, we need to be transparent in how we do this. Our eligibility policies ensure that we target our services to socially and economically disadvantaged people, and at the same time, we've been accountable to the public for expenditure of public funds. The policies also ensure that every applicant is treated in the same way. Slide 5 looks at Commonwealth family law matters when legal aid is available. The Commonwealth family law policies cover matters such as parenting matters, varying and discharging parenting orders, and in these matters, there must be a material change in circumstance for your client to be eligible. We look at we look at recovery orders. This may include location and Commonwealth information orders and property settlement matters. All the family law policies are available in Policy Online at Chapter 5. There is a link in this slide to Chapter 5. This is a continuing of the family law matters when legal aid is available. So it includes spousal and de facto maintenance orders, child support and maintenance matters. It looks at contravention and parenting order and enforcement of court orders. It looks at divorce, international abduction, which are the Hague Convention matters, and matters after final orders. Again, there is another link to the family law policies, which give more details of the policies at Chapter 5. In Commonwealth matters, the eligibility tests that are applied to most family law matters is the means test, merit test B, and the availability of funds test. Today, we will look at parenting matters, so when legal aid is available. For legal aid to be granted to parents in parenting matters, the following tests must be satisfied: the means test, merit test B, and the availability of funds test. And there must be a dispute about a substantial issue. Here we look at what a substantial issue is. In fact, what we describe in our guideline is what's not a substantial issue in dispute. So, unless the applicant discloses domestic or family violence, the following types of disputes will normally not be considered a substantial dispute: where there's no active dispute, for example, where the other party is not seeking to spend time with the children, where the dispute concerns minor issues such as the children's clothing, routine, or activities, disputes about minor increments of time, for example, an increase, decrease in nights per fortnight, or an earlier, later drop off time, disputes about changeover location or associated travel costs, disputes about the choice of child's school, method by which the parties are to communicate with each other or the child, change of the child's name, and or obtaining orders to enable holiday travel arrangements. This list is available on Family Law Guidelines, and there's a link in slide 9 to Policy Online at 2.18. Slide 10, we're looking at property settlement matters. Recently, the Legal Aid Board has approved expanding this policy, and we are now granting aid in quite a number of property matters. The property settlement matters are subject to means test, the merit test B, and the availability of funds test. And legal aid must be satisfied that the dispute relates to the matrimonial or de facto home and or superannuation, and the estimated equity in the home and or the deferred benefit is more than 20,000, or where the applicant is not retaining their home or the dispute relates to property other than the home or superannuation, the applicant's experience of domestic or family violence or a disability is likely to impact on their ability to effectively negotiate a reasonable property settlement, or there are exceptional circumstances. On slide 11, you will see a link to the family law policies at 5.6, which set out the property settlement policies in detail. We also have a composite property policy, and this is where an applicant has a parenting and a property matter. Legal aid expects that the proceedings will be conducted together. So, unless there are exceptional circumstances, this means an applicant must be eligible for their property matter to be funded for the property and the parenting matters. So, this policy is set at 5.6.2. We are now going to look at a case study. This is Alima's story. Alima was separated from her partner for over 18 months. She had experienced significant domestic and family violence when she was married. She left the family home once her children were adults. When she came for advice to her solicitor, she informed her solicitor that she thought all they had in property was the family home. She estimated that there was about 500,000 equity in the home as they still had a small mortgage. She was living with her eldest son at the time she came for advice, as she had left the family home. So, is Alima eligible for legal aid? Well, Lima has applied for a property only, and that means yes, she is eligible, as you no longer need to have children's matters. You can have property only matter. She had experienced domestic and family violence. She's not retaining her home, but she's experienced domestic and family violence, and which will impact on her ability to negotiate a fair settlement. So Lima applied for legal aid and she was granted legal aid. Lima is also expecting about 250,000 from her property settlement. This means she satisfies the means test. So to be eligible under the means test in terms of asset, Alima can have up to 260,500. Alina meets this as she has 250,000 assets in her property. Now we're going to look at state family law matters. The state matters for which aid is available are care and protection proceedings, adoption, special medical procedures, and compulsory schooling orders in the children's court. The other eligibility tests that apply in most family law matters are the means test, the merit test, and the availability of funds test. Care Matters is available to parents, children, and people who are significant to children. The details of the care and protection policies are in Policy Online at 5.14. Currently, parents in care proceedings and primary care proceedings are not subject to the means test. This means the only test applied is the availability of funds test. Children are not subject to means or merit tests. People significant to the child must satisfy the means test, the merit test, the availability of funds test, and also legal aid must be satisfied there is a benefit to the child or young person that might be gained by the applicant receiving aid. Slide 17 looks at adoption matters and when legal aid is available. So, legal aid is available to birth parents, siblings, and grandparents who are responding to adoption proceedings subject to the means, merit, and availability of funds test. We generally give birth parents and relatives assistance with ensuring there's a suitable adoption plan in place. Slide 18 are some of the resources that are available to you and your staff. Policy Online can be accessed under the For Lawyers sign on the internet. You will see that Family Law Matters, then under Policies, Family Law Matters, and when legal aid is available, and you can click that to see all the family law matters. This gives you the detail of all the family law matters. So it there covers the parenting matters, the varying and discharging of parenting orders, property settlement matters, child support, and contempt of court. Do you need more information? So, policy resources that are available on the Legal Aid Internet include Policy Online, Policies in Brief, the A to Z Guide to Policies, the Means Test Indicator, and there's also a learning management system module that you and your staff can access, and that gives more detail about the policies. You can contact the Client Eligibility Unit with any questions you have about eligibility, and our email address is there on slide 21, or you can contact Aideen McGarrigle on 9219 5701. For any further information, you or your staff, if you have any questions about eligibility for legal aid.